My name is Nathaniel Pitoniak and I'm a criminal defense lawyer in Houston, Texas. I want to talk to you about theft or embezzlement cases. The first thing that should be determined when you're facing an allegation such as this is whether a theft even occurred. In order to prove theft, the prosecutor has to establish evidence that you took somebody's money without their effective consent. In the context of a white-collar theft charge, this is not necessarily a given. Oftentimes, the nature of the business relationship, the nature of the employment relationship can be a useful area to investigate because it may be the case that while the complainant says that you stole money, you may have had the effective consent of the complainant to take that money. You want your defense lawyer to be fully aware of the nature of the business relationship or employment relationship you had with the complaining witness. Oftentimes there are a lot of documents to go through and a lot of evidence to gather. Your defense lawyer can gather financial records, business records, and employment records and present that evidence to a grand jury. A grand jury may, after looking at all of the evidence, decide not to indict your case, which means that your case would be dismissed and you could avoid going to trial. If a grand jury does decide to indict you, we now go to the second step, which is defending your rights at trial. We may decide to retain the services of an expert forensic accountant to determine where money went and whether it was supposed to go there. In other words, we may be able to create a reasonable doubt as to whether you deprived the complaining witness of money without their effective consent. If you've been charged or are facing the allegation of a theft or embezzlement case, it is imperative that you reach out to a Houston criminal defense lawyer as soon as possible to help protect your rights. Please feel free to call me at 832-315-6283 so we can discuss the facts of your case.